Lawyers, what is the sleaziest thing you've seen another lawyer try to slip into a document contract? I got laid off from Technocore Solutions in March 2019 after 3 years as a software developer. It wasn't personal. They were downsizing their entire development team after losing a major client. My manager, Jim, pulled me aside and said they wanted to bring me back as a contractor for a specific project that would last about 6 months. The money was decent, and I needed the work, so I agreed. But when their lawyer sent over the contractor agreement, I knew something was wrong. The document was massive, like 40 pages for what should have been a straightforward freelance gig. I started reading through it carefully, which is something I normally wouldn't do with employment paperwork. But since I was going to be a contractor, I figured I should understand what I was signing. That's when I noticed the weird clauses scattered throughout the document. They weren't grouped together in one section like you'd expect. They were buried in different paragraphs, mixed in with standard boilerplate language about payment terms and project deadlines. One clause, stuck in the middle of a paragraph about invoicing procedures, said that Technocore would have ownership rights to any software, algorithms, or computer programs developed by contractor during the term of this agreement. Another one, buried in a section about confidentiality, stated that I would assign all intellectual property rights for any programming work performed during the contract period to Technocore Solutions. But the most ridiculous one was hidden in a paragraph about work schedules. It said Technocore would have full access to and responsibility for any computer-related activities performed by contractor, whether on company time or personal time, during the contract period. I'm not a lawyer, but I've been programming since high school. I knew that language was insanely broad. According to that contract, if I wrote a simple script to organize my personal photos, Technocore would own it. If I contributed to an open source project on weekends, they'd have rights to that code. Hell, if I posted a helpful comment on Stack Overflow, they could theoretically claim ownership. I called their legal department and got connected to their in-house counsel, a guy named Robert Mitchell. I explained my concerns about the intellectual property clauses. Oh, those are just standard protections, Robert said dismissively. We need to make sure any work you do for us stays with the company. But these clauses aren't limited to work I do for you. They cover anything I do on my own time that's remotely related to computers. Well, we need broad protection to avoid any potential conflicts of interest. I tried explaining that I had personal programming projects, that I maintained a GitHub account with open source contributions, that I sometimes did freelance work for other clients. Robert kept insisting that the language was industry standard and non-negotiable. This went back and forth for 2 weeks. They'd send me a revised contract and the same clauses would be there, just moved to different sections. Sometimes they'd reword them slightly, but the effect was the same. They wanted ownership of basically everything I touched that involved code. Finally, I got frustrated and called Robert with a different approach. Hey, I have a question about this contract. If Technocore is taking full responsibility for my computer activities outside of work, does that mean you're accepting liability if I do something illegal on my personal computer? There was a long pause. What do you mean? Well, the contract says you have full access to and responsibility for any computer-related activities I perform, right? So if I accidentally download copyrighted material, or if someone hacks my personal laptop, or if I visit websites I shouldn't visit, Technocore is liable for that, right? That's not what that clause is intended to cover, but it's what it says. You want ownership and control of my personal programming work, which means you're taking responsibility for all my computer activities. I just want to make sure I understand the liability implications. Robert started backpedaling immediately. The clause is specifically about intellectual property related to your work for us. That's not what it says though. It says any computer-related activities. That's pretty broad. I mean, if you're claiming ownership of my personal GitHub contributions, you're also accepting responsibility for my entire digital footprint, right? By the end of that conversation, Robert sounded very uncomfortable. The next morning, I received a completely rewritten contract. All the sneaky intellectual property clauses had been removed, and the language was limited to work I actually performed for Technocore during business hours. I signed the revised contract that afternoon. The project went smoothly, and I never had any more issues with them trying to claim ownership of my personal work. But I learned an important lesson about reading contracts carefully. They tried to slip those clauses past me by spreading them throughout the document and burying them in unrelated sections. If I hadn't taken the time to read every paragraph, I would have essentially signed over the rights to everything I'd ever programmed, plus everything I might program in the future. The funny thing is, once I pointed out the liability implications of their overreaching language, they backed down immediately. Apparently they wanted to own my work, but they definitely didn't want to be responsible for my potential legal problems.